Hi there and welcome to Employment Hour in 30. I'm John Scholes. He's Lior Samfiru. This is about workplace rights and employment law. If you've never caught our show before, stick around. The next 30 minutes are very important. About 1,800 hours a year. That's how long the average person spends at work. So you got to know what's going on behind the scenes with your work, with your boss, with your rights, with your severance. Everything that we talk about on the show is key information. We'll get to a lot of talking points, some calls from our 1 hour radio show. We like to play some of those back for you. And we'll talk about the severance pay calculator. If you're not familiar with that, you could be part of, 500,000 people that have already checked out the severance pay calculator. You can do it now, severancepaycalculator.com. But we always start off, my brother, with a segment we call The Week That Was. What's been happening with you?
You know, actually, I was gassing up my car recently, and someone stopped me at the gas station, said they watched the show, and because they watched the show, when their brother lost their job, they told them to go to the Severance Pay Calculator website, and it helped them out, and that's wonderful. I mean, that's really what we're here to do, to inform and educate people that may not otherwise have access to the legal information about their job, to give them that information, to give them that support, and to make sure that they know that if they're suffering from a situation at work, if there's a problem at work, there's a solution. There's always a solution. So that's what we do on this show. We talk about your workplace rights, your employment law situation. If you have a question, you can reach out to me at any time. We'll give you that contact information throughout the show. Otherwise, tune in and hopefully we can help you learn some new things. Yep. And week that was is, John, as you said, a situation that came across my desk over the past few days. We've talked before about termination for cause, and this is termination for cause is a situation where the employer lets the employee go because supposedly the employee did something so bad that now the company can let them go without a severance, without any compensation. And I've said before, it's extremely difficult to terminate someone for cause. So this situation I'll tell you about is a great example of that. I spoke with the gentleman that was put on a performance improvement plan a couple months back. And yeah, his performance was lagging. He was doing his best. He was still learning the job. And after the performance improvement plan over about a month, they told him, you're still not improving. We're going to give you another couple weeks to show us that you can do the job properly. He busted his butt, did his best. But after a couple weeks, they said, you're still not performing. We're letting you go for cause. Now, from the company's perspective, they thought, well, we put him on a performance improvement plan. We kind of give him this warning so we can terminate him for cause. He called me and he wanted to know if that is the case. Absolutely not. That's not cause. Now remember, this is not a person that's slacking off at work. This is not a person that's deliberately trying to do a bad job. No, not at all. He's doing his best. He's learning. He's getting better. Maybe not as good as or as fast as the company wants him to, but that's not cause for termination. It's so difficult to establish cause that you really would have to show, if you're the company, that on purpose he was trying to do a bad job. The fact that you've been put on a performance improvement plan, the fact that you've received a warning does not mean you can be let go for cause. In most cases, John, if you're let go for cause, that is a wrongful dismissal. It's this case here, and it's especially difficult to let someone go for cause for performance reasons. Like I said, you almost have to show that they're doing it on purpose.
Now, if you put on your employment lawyer hat for the employer, what should have been their next step rather than letting this guy go?
I think, first of all, they should have shown that they've done whatever they can to help him, provide some training, some help, and give him more time, okay? At some point, the company could potentially terminate for cause, but that will take time for performance reasons. They have to give him the opportunity to improve. They have to provide him training and help and support, and maybe then they can show that it's cause. They jumped the gun. Very common situation, by the way, where the employer jumps the gun. So that is a wrongful dismissal.
Well, you often say, very tongue-in-cheek, that it's the death penalty of the employment relationship. That is being let go for cause.
Yeah.
Right?
So the question is, you ask anyone, is this person deserving of the kind of the death penalty? Right. No, he worked hard, he did his best. Of course that's not cause. So the nice thing to understand is, because it's not cause, you get full severance. Nice. You don't get some sort of a discount because you weren't necessarily doing the best job. You get your full severance.
By the way, 1-855-821-5900 and employmenthourtv.ca to reach out. You can also, once you're on that website, find where you can catch one of our 1 hour radio shows, which we've been doing for some time. We take a ton of live phone calls on the show. We cherry pick some good ones that are informative and you'd like to hear, we'd like to comment on, and we'll play some back right now.
My work is closing there at sales. I'm 48, and we've talked about severance. They said, you've been here 19 years, you get 19 weeks. Anybody else in the center under 5 years gets nothing. I said, well, how are you basing that? And they said, the standard labor standards. And I'm like, well, doesn't common law say I should get more? And they're like, well, no, we don't use that.
The old week per year, huh?
The old
Yeah,
week
the
per
old week
year.
per year.
And you know, the reason we picked this call, not it's because it's unique. We picked it because it's not unique. We picked it because it's common. So many people are going to face the exact same situation. They're let go after many years of service. The company says, here's your week per year of service. Now, interesting thing is, this person, I think he had heard our radio show, maybe watched our TV show before, and he knew that under common law, he has additional entitlements. So he asked them about it. Hey, what about my common law entitlements? And they said, oh, no, we don't do that. That's not something that we do. Well,
we don't believe in it.
Yeah, well, it's just religious reasons, maybe.
That's right,
no,
we don't believe in it.
It doesn't work that way, okay? The law decides what you have to pay. You don't get to decide if you're going to comply with the law or not comply with the law. And the law says that after 19 years of service, he gets a lot more than a week per year of service, and same with you at home. So how much does he get? Well, let me use the severancepaycalculator.com website to show everyone at home how that works. So we know he's in sales. We know he's been there for 19 years, and he's 48 years old. He was offered 19 weeks pay, and the severance pay calculator, as you see on the screen right now, correctly assesses him as being owed between 16 to 20 months pay. 16 to 20 months. So he was offered 19 weeks. He's owed another year on top of that. That is how big a deal it is. So if he would have accepted his 19 weeks, he would have found out later, oh my gosh, I would have been owed another year's pay.
Right.
He knows better. He called us. We resolved that matter. Same thing for you at home. If you lose your job, you know someone else that lost their job, don't let them fall for this misconception. Tell them to call me. Tell them to go to severancepaycalculator.com.
You know, and the thing is, as you mentioned, he's probably either caught this TV show or he's listened to a radio show in the past, and he knew. But if he were to take that offer on paper and ask his neighbor, his brother, or whatever, they say, yeah, it's a week per year, man. You're okay. You're good to go.
It's the standard. It's what the company has to do. Well, it's not. So you have to understand that, and you have to only get advice from people that actually know, not your next door neighbor, even though I'm sure he wants to help you. So no, it's not a week per year. Check out severancepaycalculator.com.
And check out employmenthourtv.ca to catch that radio show from which we got that call. We'll get to a second call right now.
An employee is sick for 2 years and is on long-term disability. Is the employer able to terminate that employee while on long-term disability, and what does that entail?
It's a very good question. So here's how this works. Obviously, the employee's been away for a long time, 2 years in this situation. So the question now becomes, is there a likelihood of this employee ever going back to work? If there is, if the doctor is saying, yeah, he's trying to get better, we're hoping that at some point he's going to go back, then the company cannot terminate. If they do, that would be a human rights violation. That would be illegal. They
Because he's trying to mitigate it.
Because he's able to go back to work, and they have to keep his job open. On the other hand, if it's not likely that he's going to come back to work, the company can call this a frustration of contract. If you've been off for work for a long time, if it's not likely you're ever going to come back to work, the company can end the relationship with you on the basis of frustration of contract. And in that situation, you're not going to get your full severance. You're only going to get your minimum severance. So very important to remember that. But the company generally cannot let you go because you're on a medical leave, even if you're on for 2 years, for 5 years. As long as there's a possibility of you going back to work, as long as you're working with your doctors to try to get better and healthier to get back to work, you cannot be fired.
Let's assume that they are not coming back. It is a frustration of contract for the employer. You said your minimum severance. Now we're going back to the Employment Standards Act. That's when it's safe to use that?
That is exactly when it's safe to use. And a frustration of contract, instead of getting your full entitlements, what we call your common law entitlements, you're going to be limited to the minimums in the Employment Standards Act, which is either a week or 2 weeks per year of service, depending on a number of factors, but which can still be a lot of money. I mean, for example, if this guy's been there for 25 years, he could be owed 30-something weeks pay. That's a lot of money. So remember that. There's potential money there as well. But you can only be let go if you've been off for a long period of time, number one. And number two, if there's no likelihood of coming back to work.
Questions when we're not here, of course, on the air. 1-855-821-5900 is a good way to reach out and get a hold of Lior or a member of his team. We always take a segment every show. I ask you 4 or 5 questions under that topic, and we expand on them. This week it is Lior, what should I do? That's going to be the topic for this week. First one, Lior, I've been placed on a temporary layoff with no set return date. What do I do?
And by the way, that's usually how calls start when people call me at the office or email me like, here's my situation, what should I do? And that's why we wanted to talk about that. So the old temporary layoff. Well, you've been placed on a temporary layoff. What you should do is you should treat that as a termination of your employment. A temporary layoff is a termination. In other words, your employer does not have a right to lay you off temporarily. You can treat that as a termination and get your severance. So that's what I advise people to do. in most cases. And the reason for that is if you don't, then by going back to work, if they even call you back to work, then you've given the company then the right to do it again. And the next time they lay you off temporarily, you can't do anything about it. You can only treat that as a termination the first time it happens. So what do you do if you've been laid off temporarily? Call me. Don't do anything before you do. But you're right at that point will be to treat that as a termination.
So you have one shot at this point.
One shot and one shot only. Once you go back to work, you've given the company the right to do it again, and then you could be off every year for months at a time. A very bad situation.
My manager is putting me on a performance improvement plan. There you go. I'm worried that they will use this to fire me. Lior, what do I do?
Well, first of all, if you believe that the performance improvement plan is not fair, say so. Put that in writing, send an email, a memo, say that I don't agree, and here's why I don't agree. What you don't want to have happen is you don't want to be considered to have accepted and agreed to it, unless, of course, you agree to it. So that's number one. Number two is this. Remember that just because you're on a performance improvement plan does not mean that the company can let you go for cause. Just as I said at the beginning of the show today, they will likely still have to pay you severance unless what you've done is awful and terrible. So respond to it, and remember that if you do lose your job, you get severance. Call me, go to severancepaycalculator.com. Make sure you get everything that you're owed.
You want to email as well, help@employmentlawyer.ca. We were talking about this week. The topic is, Lior, what do I do? Number 3 on our list is the boss is giving half of my hours to a new, younger employee. What do I do?
Well, that could easily be a human rights violation.
Right.
If you're not getting hours or your hours are taken from you because of your age, that's illegal. And by the way, it doesn't just apply to hours. If you're fired because of your age, if you're demoted because of your age, if you're not treated properly at all because of your age, that's illegal. That cannot happen. That's a human rights violation. So if you believe and you feel that the reason you're not getting hours or the reason someone else is getting your hours is because of your age, you may have a human rights claim. But even that aside, if your hours are taken away from you, obviously that's a change to the terms of your employment. That's a constructive dismissal. Even if the employer is not doing this for discriminatory reason, maybe they're doing it because the business is slow, they don't have a right to do it. So you can treat that change in hours, the reduction in hours, the reduction in pay as a constructive dismissal and leave with your full severance, but you want to act quickly. If you let that happen and you sit on it for a few weeks or a few months and don't do anything about it, you're considered to have accepted it, and then you're stuck.
And as you always say, one of the key points in anything like this is if you don't agree to it, get it in writing. Send an email, a written note.
Absolutely.
Right?
Always remember, silence is the same as saying, I accept.
Right. Number 5, or at least number 4 on our list of Lior, what should I do? I'm ready to return to work from a leave, but my boss has said that I have no job to return to. Although he's a nice guy, he's offered to help me get EI.
That's very kind.
That's very sweet.
Well, here's the thing. If you're coming back from a leave, the company has to make every effort to take you back. So that means looking for your old job, trying to fit you in, trying to find another job for you within your job description. Make all efforts. If they do that and they still can't find a job, you've been off for a while, there's just no position for you, they've tried their best, they can terminate, but they have to pay you your full severance. But they have to go through that analysis. If the company simply says, no, we're not going to even try, we're not going to even try to bring you back or look for a position, and they terminate you, that is not just a wrongful dismissal, that is also a human rights violation. They can't do that. So the key is really as to what efforts the company has made to take you back. If they've made those efforts, there's no job, you get your full severance.
Now, the company, as we know, does have a right to maintain business and keep business going, so they might have to replace you while you're off.
Yep.
So while you're off, the boss says, you know what? Sally over here is a much better worker than the one that's off. I want to keep her. Does he have a choice? Can he do anything?
Well, the interesting thing is, in a maternity leave situation, you can't do that.
Right.
So you can't say, well, I like your replacement better than you, so I'm not going to take you back from maternity leave.
Yeah.
They can't do that. They are able to do that, though, with a disability leave. They don't have to fire your replacement to make room for you. Okay? What they have to do is to see whether they can still fit you in somewhere legitimately. If they don't, if they don't try, then that's a human rights violation, arguably. If they try and they can't, you get your full severance. And potentially even more severance than usual. If you're still dealing with health issues, so it's going to take you longer to find another job, you may get additional severance.
Under the banner of Lior, what should I do? We'll get to one more before we break here, and that is I've just been fired, and I got 48 hours, 2 days to sign an offer, and the company says it's very generous, so get it back to us.
Well, spoiler alert. It's not generous.
Yeah, right.
I haven't seen this offer. This is just a question. Yeah. But I've been doing this for 15 years, and I've reviewed thousands of offers, and I can tell you that it's not generous because almost everyone that's handed an offer, not only is the offer not generous, it's a lot less than what it should be. Okay, generous would suggest that it's better than it should be.
Yep.
So don't worry about that deadline. I've said this before, I'll say this forever. That deadline is meaningless. Whether it's 48 hours or 72 hours or a week, doesn't matter. Your job, when you lose your job, your role is to make sure that you get what you're owed, that you figure out how much you're owed, not what the company wants to pay you or thinks they should be paying you, how much they actually owe you. So call me, let's sit down and go over it. Go to severancepaycalculator.com. That offer is not generous.
And don't panic about the 48 hours, right? 2
It's
days.
meaningless. You have 2 years to pursue your rights. They don't expire in 48 hours or Friday. They don't expire. You have the time.
Reach out 1-855-821-5900 and employmenthourtv.ca. We'll take a short break. When we come back, we'll get into the severance pay calculator. And pregnant and out of a job, we'll deal with that too. Employment Hour 30 continues. Stick around.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact. The labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour 30. This is the part of the show where you can actually participate. Simply go to severancepaycalculator.com, punch in your information, and find out what comes out the back end. It is amazing. It is a lot more than you think it's going to be, or what your friends think, or your Uncle Bob thinks. That's why this thing was created, 6 years ago, and over 500,000 people have tried it. Severancepaycalculator.com. Details. Talk about it.
Over 500,000 people. That's incredible. It really is. It's mind-boggling for me. But severancepaycalculator.com, if you haven't heard about it, you really do need to know about it, and you need to tell others about it. It's the tool that allows you to find out what is that you're owed if you lost your job. It's not a week per year of service. We said that in the previous segment. It's not 2 weeks per year of service. It's not only for small companies or big companies. It's for everyone. Severancepaycalculator.com. Once you go there, you're going to answer questions about your age, your position, and the length of your employment, and then you're done. It's going to tell you how many months' pay you are owed, the real amount, what the law says, not what the company says, not what they want to pay you, not what the Ministry of Labor, unfortunately, misleads people about. So go to severancepaycalculator.com, even if you haven't lost your job, but you're curious or you're worried about your job, you've always wanted to know. It's free, it's anonymous, there's no strings attached, it's just there for your information. And if you want to, you can contact me directly from that, severancepaycalculator.com.
You know what, we'll take it for a spin. I got an example here that we'll run through the calculator and see what you think. It says after just 1 year and 10 months into her job as a senior manager at a software company, Courtney was terminated from her job. No warnings, just a letter from the company saying the relationship is not working. She was given 2 weeks' pay. She's 43 and earns $105,000 per year. Is she owed more?
Well, I like this example, John, because she's a short service employee. She's been there for just under 2 years. And a lot of people think, I guess it would make sense to think that if you've worked for a short period of time, you don't get any severance or maybe very little. Well, you've worked there for 2 years, you're going to get a couple of weeks' pay. You should be grateful to get that.
Right.
Well, not so fast. In fact, John, the opposite is true. Short service employees, I want you to pay attention to this. Short service employees are treated disproportionately better. They're treated better than longer service employees. So the fact that you work for a company for a short period of time does not mean you don't get severance. You get severance usually that's measured in months. So let's use this example you just read. Let's plug that into the severancepaycalculator.com website and let's see what we come up with. So she's a manager, been there for 1 year and 10 months, 43 years old. You know, we know she makes $105,000, very nice salary. She was offered 2 weeks' pay. A lot of people would have said that's fine. Severance calculator correctly assesses that she's owed 4 to 6 months' pay. Now, for her, that's an additional anywhere from $30,000 to $50,000 difference. That's a lot of money, John. And this is not some sort of a pie-in-the-sky, crazy, outrageous number. It's what the law says she gets. Right. And that works for short service, long service employees. And if she would have accepted this 2-week space, she would have walked away potentially from as much as $50,000.
And that's the money she has to keep and get her through till she finds another job, which was a nice job, by the way. She was a senior manager.
Yeah.
Not that common, right?
To pay her bills,
Yep.
to pay other expenses. I don't know, maybe she has kids in university.
Right.
Those are all expensive things, and you need that money to get you through to that next job. That's what Severance is intended to do.
Again, severancepaycalculator.com and employmenthourtv.ca is the source to find our 1-hour radio show, which we've been doing for years and years. Love doing that. We do a lot of live phone calls on the show, play them back on this TV show, and we get you to comment on them. We'll get to one.
I'm with the company right now. I've been there for 30 years. Management, stable company, stable job, not going anywhere. But if I'm looking at leaving this company for employment at another company and they let me go a week or 6 weeks or a year into it, what's my recourse?
Yeah, and it's a difficult situation. You don't want to leave a secure job. You've been there for a long time, in this case 30 years, to take on a new job. What happens if they let you go a month later? Well, so here's what you do. Number one is if you're recruited from a company, then you actually may have enhanced severance. So if you have a secure job, a company comes, recruits you away, you're not looking to leave. Induced, exactly. You're learning, that's all right.
We're good.
And you're induced to leave. And then they let you go, you actually may get credit for the time spent with the previous company. So that's important to remember, which means you don't want to sign an employment agreement that limits your future severance, because you could potentially be walking away from a lot of money. Very, very important. Beyond that, even if you're not being recruited, pay attention to your employment agreement. It's so important. So whether you leave a secure job, whether you're just accepting a job, oftentimes employers are going to try to include a term in the employment agreement that limits your severance. Why? Well, because they want to save money.
You bet.
So it's your job to make sure you don't have that, to negotiate that out. In fact, if you're going to leave a secure job, you may even want to negotiate something that's even more generous than what the law would provide for you. Protect yourself at the beginning of the employment relationship, because if you don't care about it in the beginning, you're going to care about it in the end.
So two things: if you're being recruited, pulled by another company, number one, don't worry about a temporary, or at least a 3-month probation period. Never do that.
Don't have a probationary period. Absolutely not.
And you really should have more leverage because they're coming to you, so you should be able to deal in your own.
If they want you, if they're convinced you're the right guy or girl for them, and you already have a job, you can negotiate hard. You can negotiate terms that are favorable, but you can't negotiate unless you know what you're agreeing to. So you may want to reach out to me, have me read the employment agreement, suggest how it can be modified. Be very smart about it at the beginning of the employment relationship.
Make the phone call, 1-855-821-5900 to get a hold of Lior and his team. We'll take a short break. Still to come, pregnant and out of a job. We'll deal with that after we come back from that break. Employment Hour in 30. Stick around.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact: over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact: in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. Still some more time to go here. You want to get a phone call to Lior when we're not doing the show, 1-855-821-5900. And we also do a weekly radio show, which we've been doing for many years. We get a lot of phone calls. People nonstop on that show have questions, have comments. They're scratching their head a lot of the time. And we like to cherry pick some of the good calls, play them back on this particular show, and get some feedback from them, right?
I've been working for 11 years now, and I've noticed that I was originally hired as an employee, and as of this year, I'm now registered as an independent contractor, and they're cutting my hours. I really feel that I'm being treated unfairly and that I have more seniority than anyone else in the company.
There's nothing right about that phone call.
No, it's wrong on many levels, so I'll break this down. First of all, he's not an independent contractor. He's an employee. We've talked about this before on the show. You can't just switch, hit a switch and one day you become a contractor when you were an employee before. He's misclassified. And there's people watching us right now, John, probably hundreds of people watching us right now that are misclassified as well. They believe they're independent contractors. They think they've been independent contractors for years. But the law considers them to be employees. If you have a regular job, you've been there for a while, you're an employee, same as this person that left us the message there. So he's an employee. Now, what does that mean? That means that if they're now reducing his hours, which affects his pay, that's a constructive dismissal. They can't do that. By the way, they probably couldn't do that even if he was an independent contractor, but that aside, certainly as an employee, they can't reduce his pay. So what does that mean? It means he now can treat his employment again being the key word, as being terminated. So he gets severance. To see how much severance, again, I'm going to go back to severancepaycalculator.com, plug his information in so everyone can see what kind of entitlements he may have. So 11 years of service, I picked the clerical position, age of 52, just to give us an idea. And Severance Calculator correctly assesses him as being owed around 10 months of pay. 10 months pay, nothing to scoff at. So that is how it works. That is his rights. He's an employee. It's likely a constructive dismissal because they changed the terms of his employment. He can leave and get that 10 months of severance. So he needs to reach out to me and we can connect and get that done.
Another way to reach out, now that you mentioned it, terminationquestions.com. You can simply ask your question there. There's a good chance it's been asked already, and there's been a very in-depth, complex answer to your question. If not, type it in there. Lior, a member of his team, will get to it and get you a reply. Again, terminationquestions.com. Example right here. When I was told, or at least when I told my boss I was 4 months pregnant, her mood completely changed. She started harassing me, accusing me of becoming lazy. I was eventually fired 2 months later without a specific reason. Is that right?
Well, John, it's a whole bowl of wrong.
Don't mess with mama.
No, you don't mess with mama. There's so much wrong here. So clearly, you don't become a bad employee just because you get pregnant. So clearly what's happened here is that the company was unhappy with her for being pregnant, or potentially unhappy with her for having to take maternity leave. So they started maybe trying to come up with an excuse to let her go. And that's so obvious. I've seen it many times. If someone is a good employee, and all of a sudden they're pregnant, and now they can't do anything right. Now they're getting written up and warned and ostracized. It's clearly because of the pregnancy. And then what does this employer do? They actually go ahead and fire her. You don't do that. That's illegal. One of the most basic rules, basic laws when it comes to employment is you don't mess with mama. You don't fire someone, punish, penalize, criticize someone that's pregnant, someone that's taking a maternity leave. So what does that mean for her? Of course she's owed severance, not even a question. But beyond that, there could be damages from under the Human Rights Code. There could be damages under the Employment Standards Act. This company did it wrong completely, and I want everyone to remember that. You have this cocoon of protection around you if you're pregnant or if you're a father that's taking a parental leave. You can't be penalized or mistreated in any way. If the company still does that, the law is going to come down very hard on them.
As far as pregnancy is concerned, is there a legal time when a expecting mother or father, for that matter, should tell the company, look, I'm going to be off in a month, 2 months, 6 months, 8 months?
Strictly speaking, you're supposed to tell the company a number of weeks before, but it doesn't matter. Actually, our courts have said that, our Ministry of Labor have said that. You can tell them whenever you want to tell them. You still have a right to your job. Now, in most cases, the mother or the father are going to tell the employer in advance because they'll know when they're going, but you don't lose your rights. You don't lose that cocoon of protection because you haven't told your employer till the last minute. So that's your right to do that.
I can squeeze this one in quickly. Again, terminationquestions.com. Basically hired a year ago, told I was given a contract to sign, never happened. What happens if they come with a contract now while I'm in midstream employment?
Well, now you don't want to sign a contract. Okay, you don't. And some people say, well, I want to sign a contract. No, you don't. Okay? If you're an employee, you are better off working on a handshake. You're better off working on an email. You do not want to sign an employment agreement if you can avoid it. Why? Because if you don't sign an employment agreement, that means you have the full protection of the law. An employment agreement limits your entitlements, takes away some of those protections that you otherwise have. So for an employee, you're better off not signing. So ignore it, leave it be. And if they still insist on you signing, you're going to say thanks, but no thanks, because you already have a job. Very important.
And if they fire you for it? Phone call.
If they fire you for it, you get your full severance. They can't do that, and that's going to be a big problem for the company.
Good for another week. Again, terminationquestions.com was a resource for those who want to reach out. 1-855-821-5900. You have help at employmentlawyer.ca, and I did mention several times that we played back phone calls from our radio show. That's easy as well. employmenthourtv.ca in the first place you always go when you get let go or otherwise, just for interest's sake, severancepaycalculator.com. Thank you so much for watching. We'll catch you again next week right here on Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.